Now we will discuss the very concept of negligence as it is recognized under Roman law. So, under Roman law, negligence may exist in varying degrees as was recognized under Roman law as a standard of care, and in that varying degrees as culpa levis and culpa lata. So, culpa levis is otherwise means failure to show diligentia maxima, that type of care which a good father as head of the family would show in his transactions, and culpa lata under Roman law means the failure to use any reasonable care. So, such failure to show ordinary diligence and reasonable care, amount of care which would ordinarily show in his action by a person, and it is under Roman law considered as negligence. And jurists, they divide negligence as gross, ordinary, and slight negligence. So, to render a person liable for neglect of duty, there must be such a degree as to amount to gross negligence on his part. And in the leading case, that is Andrews versus Director of Public Prosecutions in 1937, Lord Atkins observed the principle to be observed in cases of manslaughter in driving motor cars are but instances of a general rule applicable to all charges of homicide by negligence. Simple lack of care, such as will, constitutes civil liability, is not enough. For purposes of criminal law, there are degrees of negligence, and a high degree of negligence is required to be proved before the felony is established. So, the determination of the principle of standard of care has no hard and fast rule. It depends upon the circumstances of each case. And in the next leading case, that is Skinner versus LV and S.C. Railways, where two trains belonging to the same company collide. The fact of the collision raises the presumption of negligence if properly controlled, do not run into one another. So, in our next leading case, that is Britannia Hygienic Laundry Company versus Throney Craft, the rule was been defined as where you have the subject matter entirely under the control of one party and something happens while it is under the control of that party, which would not in the ordinary course of things happen without negligence. You may presume negligence from the mere fact that it happens, because such a thing could not happen without negligence. So, as we discuss negligence as it is being recognized and provided under the Roman law in two forms, culpa levis and culpa lata, so also gross ordinary or slight negligence as it is divided by the jurist, and so also some important leading cases like Andrews versus Director of Public Prosecution 1937, Skinner versus LV and S.C. Railways, so also Britannia, Hygienic Laundry Company versus Throney Craft. So we found these are the basic ingredients and that standard of care which is required from every person regarding the very liability which arises out of negligence.